Thank you, ladies and gentlemen. Our third speaker this morning is Alanna Duffy. Alanna has been a barrister for 9 years, practising mainly in the area of employment and workplace relations law. And having been opposed to Alanna on a couple of occasions over the years, can I say she's a very good opponent. Alanna appears regularly in the courts and tribunals and provides advice in matters relating to unfair dismissal proceedings, adverse action claims, discrimination claims, common law matters and professional disciplinary hearings. She will speak to us this morning on the fiduciary obligations of former employees.
Good morning and thanks, Joseph. Now you don't have a paper from me, so don't look in the folder for that, but I am speaking to a set of notes and I'll tidy those up a little bit and make them available on the website. So don't worry too much if I refer to cases and don't give the citations. That information will be available. The other thing I'm conscious of this morning is this is a very broad topic and to some extent it intersects with the matters that Carmen and Angus have already spoken about. So I think I want to try to stick strictly to time so that we've got some time for questions, particularly to sort of flesh out some of those areas and questions that people might have about the intersection of the various topics we've spoken about this morning. It is the fiduciary obligations of employees and former employees is a very complex topic, and I think probably the best I can do this morning is give you a bit of an outline or a snapshot of some of the key issues. And the fiduciary duties of employees also sit, they coexist or can sit side by side with contractual obligations, and there's a significant amount of overlap with those contractual obligations, particularly in relation to the duty of fidelity, and I think Angus has already touched on that. I should start really by just outlining really what a fiduciary duty is, and the key to a fiduciary duty really is the concept of loyalty, not surprisingly, I suppose, given the meaning of fiduciary. In particular, there is, as I said, a great overlap with the contractual duty of fidelity, and some of the matters that are picked up by that fiduciary duty include that an employee must serve the interests of their employer ahead of their own interests. They must not misuse information, and this is an important distinction because that includes information that may not be regarded as confidential information. And I'll come back to that a little bit later. An employee must not misuse their position against the interests of their own employer, and a fairly obvious one, they must not misappropriate the employer's property. Now that can extend to, I suppose, just basic theft. That's a reasonably obvious application, but it goes further than that, and that's where some of the cases get into various complexities about what is the property of the employer and whether that has in fact been either misappropriated or essentially misapplied for the employee or former employee's own benefit. There is some overlap with the equitable duty in relation to confidential information. There's certainly some, I suppose, academic argument as to whether that is in fact a fiduciary duty, but I think it's probably better described as an equitable rather than a fiduciary duty, just because it doesn't really have anything to do with the loyalty of the employee that's required to their employer. It's clear that the employment relationship is an accepted fiduciary relationship. Often you'll hear that kind of term used more to describe relationships of, say, directors of companies, trustees and that sort of thing. But certainly there's quite extensive case law that recognises it in relation to employees, and probably the the main statement that makes that very clear is of the majority of the High Court in Concutt and Worrell. The court in that case said that the critical feature of the duty, particularly in relation to employees and employers, is that the fiduciary, or the employee, undertakes or agrees to act for or on behalf of or in the interests of another person in the exercise of their powers or discretion that will affect the interests of that other person in either a legal or a practical sense. Now, there is a common perception that fiduciary duties only operate in relation to senior employees. It's certainly the case that senior employees are more likely to owe that duty because of their position and also because they're more likely to be placed in circumstances where loyalty is required and there are other opportunities or there are opportunities to breach that loyalty. But the duty itself applies to all employees, and particularly in relation to misuse or misappropriation of information or property, that would certainly come into play for less senior employees, although you'll see that most of the case law in this area probably deals with employees that we'd regard as quite senior or at executive level. There are fairly subtle differences between some of the fiduciary duties and contractual duties, whether they be express or implied. Often the discussion of those duties is essentially dealt with together in some of the case law and almost mixed up to the point that it's a little bit hard to extract sometimes. Now, given that my topic was the fiduciary duties of former employees, I was faced with a little bit of difficulty because the general rule is that where a fiduciary duty arises out of the employment relationship, it ends when the employment ends. But there are a couple of important exceptions to that rule, because the fiduciary duty continues to operate in respect of transactions or information that was current at the time that the employment terminated. And there's also an exception in relation to what could be described as business opportunities that existed during the time of employment. And that might arise in a situation where essentially an employee leaves the employment to either pursue an opportunity that became apparent to them while they were working for the employer, or even takes, I suppose, more active steps to divert business or profits from their employer while they still are in that employment. It gets particularly messy if an employee is on, and I think Angus has already adverted to this, on gardening leave. Certainly, employees are entitled to take steps to prepare for future employment, particularly whilst they're on garden leave and not actively working for their employer, but there's a very blurry line there as to how far they can take that without acting against the interests of their current employer, who's still paying them even though they're not actually at the workplace at that point in time. I should also mention, I think Angus has mentioned briefly, there's a statutory duty of fidelity as well, which is set out in the Corporations Act and applies to directors and officers of companies, which again pitches it probably at that more senior level. Now, as I said, it's very hard to pin down the fiduciary duties. To some extent, the duty owed to the employer really depends on all the circumstances, and that's certainly a matter that really takes into account the nature of the position of the employee and what sort of access they have to either information or other business opportunities or property that, of course, could be used for their own benefit or diverted away from their employer. Now, as I said, there's certainly some application of these the duties after the employment has ended. Again, I think Angus touched on this, but it's particularly important in relation to the misuse of information, given that there's some uncertainty as to whether an implied term in relation to confidential information applies after employment's ended. And there's a passage that I'll set out in the notes. The case, I think, is referred to in Angus's paper that deals with that. It's Del Casale, which is a 2007 decision of the New South Wales Court of Appeal. An important thing to note is that the duty of fidelity, which really broadly encompasses all of the types of matters that I've spoken about this morning, is a negative duty. It essentially requires an employee not to engage in conduct which conflicts with their duty to the employer, or not to misuse their position to their own advantage. But it doesn't extend so far to put a positive obligation on a fiduciary to disclose, say, a clever or useful idea, to use the terms used in the Black Magic case. That's a federal court case of 2010. It doesn't even extend, arguably, to any sort of duty for an employee to disclose perhaps almost what might be described as misconduct on their part. It's really a negative duty rather than an active one. It does extend, though, perhaps a little bit further than the law generally in relation to inventions. That's too big a topic perhaps to go into this morning, but the current state of the law in Australia seems to be that really, unless there is a contractual term which requires an employee to invent, then the property in the invention doesn't reside with the employer. There's a couple of cases, the University of Western Australia and Grey and the Victoria University of Technology in Wilson, that deal with that in detail. But I suppose an exception to that is if there is a fiduciary duty, the fiduciary or the employee may have a duty that goes beyond that, in the sense that they may not be entitled to essentially appropriate either the invention or an opportunity for their own benefit, because they are effectively holding that benefit on behalf of their employer. I might just move to what I think is probably the most important distinction, particularly in practice, between contractual and fiduciary duties, and that is the remedies available. Now, I've already mentioned to some extent that the misuse of information can extend beyond confidential information. In fact, it goes to information that is not considered confidential, which may, in a practical sense, get around some of the difficulties that Angus has described in determining whether or not information is in fact confidential. When the fiduciary duty comes into play, it's the use of the information that is important. So I think that's certainly something that's worth remembering, because there's a lot of difficulty in proving that information is confidential, whereas the fiduciary duty will extend to really the use of any information, say perhaps a client list that may or may not be regarded as confidential, but if an employer during the time of their employment, or even perhaps immediately after their employment, uses that list for their own purposes in conflict with the interests of the employer, then there may well be a remedy in the area of fiduciary duties where there wouldn't be one, either contractually or even in equity in terms of the use of confidential information. Another significant issue in relation to remedies is the damages. As you would be aware, damages for breach of contract, at least anything going beyond nominal damages, can only be recovered if an employer can prove a loss caused by the breach. Whereas the remedy for a breach of fiduciary duty is either an account of profits derived from the breach by the former employee, or equitable compensation, which is, of course, different to compensation available for a breach of contract. Now, again, in a practical sense, that may in fact be easier for an employer to prove, often when there has been some sort of breach of a contractual duty, particularly with the use of information or know-how that is considered the property of the employer. The real difficulty for the employer is to prove that there's been a breach. And that again may arise in a situation, if I use the situation of, say, a client list, to prove a contractual breach, the employer would have to show that they would have maintained those clients. They might not be able to do that. The clients may not be willing to cooperate, and that the loss of those clients effectively caused them damage, which can be quantified. Whereas if it's a matter of a breach of the duty, fiduciary duties rather, an account of profits from the work performed for those clients can be sought from the former employee. Now, as I said, I think I'm being wound up. I was just about to finish anyway, because as I said, I wanted to leave some time for questions, so I'll finish there.
Thank you, Alanna. You've heard enough from us this morning. This is now your opportunity to ask questions of members of our panel. The panel is also joined right at the end there by Jim McKenna. Jim, as many of you will know, also practices in the area of industrial relations and employment law, and in this particular area. So I invite any of you to ask questions, particular matters. You've got the gentleman here. Yes, sir.
I was just wondering what the panel's view is on cascading restraints in the New South Wales Court of Appeal. They obviously upheld cascading restraints, but the law is slightly different in New South Wales. I'm just wondering what the view of the panel would be in relation to the enforceability of cascading restraints in Victoria.
Carmen?
Can you hear me if I use this?
Sorry?
I can hear you anyway.
Thank you. Probably a couple of points to make about cascading clauses. There are sort of two main reasons why there's some uncertainty around them. And when we're talking about cascading clauses, we're talking about restraint covenants where you set out perhaps a series of 3 or 4 alternate time periods that a covenant might run for, or alternate geographic areas. The idea being that if the larger or longer time period is found to be unreasonable, that the court can put the blue pencil through it, and that leaves something less which may be considered reasonable, and you've still got a covenant there that you can enforce. The first reason there's some uncertainty around it is because there's a very strictly circumscribed role for severance in the context of employment restraints. Courts will not act in terrorem, they say, to fix up unreasonable restraints and therefore expose employees to liability. So that's the first, I think, significant thing to take into account. The second thing is that there are genuine questions about the certainty of a cascading clause. When the first thing the court has to do is construe the meaning of the clause, and if you have 3 or 4 or 5 different time periods that a covenant might run for, or alternately, there's a genuine question, can we be sure that there is certainty about what the parties intended when they entered into this clause? Similarly, there's a risk that you might have inconsistency in a clause. But as you rightly say, there's authority in New South Wales which has recognised that if you have a cascading clause and each part of it operates essentially as a separate covenant, and you've got some certainty from the intention of the parties at the time they entered into it that they meant the main, perhaps the widest one to be the one they would be bound by, then it can be enforceable. In that decision, the validity of that covenant depended on three things. It had to be expressed very clearly. Each separate part of it had to be capable of simultaneous compliance so that it wasn't inconsistent. And it also had to operate in a way that it didn't depend upon the court making a ruling about it or making some inquiry into it for it to be operative. Does that resolve it in Victoria? It's difficult to say, except that decision has given some consideration to the debate in common law around it, and it's likely to be a similar debate you would find here. I don't know whether Jim or anyone else have any comments they want to make on that.
Perhaps the effect of the Restraint of Trades Act is also relevant, particularly in New South Wales, isn't it, Jim?
It is, but the New South Wales Restraints of Trade Act doesn't, it's often described as giving the courts the power to rewrite the restraint of trade, and that's been pretty much categorically rejected by the courts of New South Wales. There is just to go back a step, there is a separate piece of legislation that exists only in New South Wales. It's only got 4 sections, it's quite a small act, but in effect, section 4.1 of that act provides that a restraint of trade will be valid to the extent that it's not against public policy. And the way that is being applied is essentially, instead of focusing on the terms of the clause itself and the terms of the clause as at the time of entering into the contract, which is what the common law requires, the Restraints of Trade Act in New South Wales allows the court to focus specifically on the breach that's alleged and to apply the restraint in those circumstances. And if in those circumstances the restraint would not be contrary to public policy, it can be upheld. It doesn't change the ability of the court or the requirements for certainty, and so I don't think that the New South Wales authority can be distinguished on that basis. And so to the extent that the New South Wales courts talk about the requirements for certainty and the other things that Carmen have talked about, I think that's directly applicable in Victoria. And generally on the point, it's perhaps an area that is ripe for a superior court to come along and express real concerns about the fundamental premise that underpins a cascading clause, because the parties to a cascading clause in an employment contract really have no idea what is going to be enforced or enforceable. And it seems, almost at gut level, there is a problem there with certainty. And every now and again, a court will say, when there is a complex combination of geographical, temporal restraints, no, that's just ridiculous, that's too hard to enforce, that's void for uncertainty. And I think that there is, at the moment, there is, I think it's pretty well settled, I'm not sure Carmen would agree, but pretty well settled that you can, the blue pencil process does work, cascading clauses are effective, but it might be an area that might be addressed at some point by a superior court.
Yes.
Picking up on something which is touched on there, which is if you have a restraint clause that is, on its face, its literal interpretation is unreasonable, to what extent will the courts take a more purposive or purposive interpretation of the clause, or try and read it down a little bit, or will they just take a purely literal interpretation and assess reasonableness based on that literal interpretation?
They're not supposed to read it down. They're not supposed to carve out parts of a covenant to make it, to fix it up, to make it reasonable, for those reasons I was mentioning before. So unless in the process of construction and interpretation of the clause, unless you can find some part of it that stands alone as its own covenant and can be severed, then a court won't start carving up or putting the blue pencil through or replacing words in a covenant to repair it.
I suppose taking an example, if you had someone who was in a very specific role and the restrictive covenant just says you will not work for a competitor. Now technically that could mean you will not work as a janitor, as a cleaner, as a whatever. Is the court likely to say, well, therefore it is too wide, it's unreasonable? They'll say, well, in this context, work for really means work for in the same kind of job, and therefore in that context, that aspect is not unreasonable. Will they go through that kind of mental gymnastics?
They'll strike it down.
Yeah.
They will just strike the clause down. My own view, usually seeking to enforce these covenants, sometimes on the other end, is that it is always better to have a tight, clear clause which may only go for an extent, a period of maximum 6 months. My own view is anything longer than 6 months, unless you're talking about particular factual circumstances, a very senior employee with particular knowledge or expertise, anything longer than 6 months is a waste of time. If you get anything enforced for longer than 6 months, you're doing awfully, awfully well, and you're very lucky in terms of the judge you were before on the day. Often one will see clauses where at the beginning of the employment relationship, they have geographic limitations, the world, if not the world, Australia, if not Australia, Victoria, if not Victoria, Melbourne, CBD. Judges look at those things and blow their tops. They don't like them. 24 months, 12 months, 6 months, 3 months. Keep it nice and simple. 6, perhaps down to 3. And also the activities which are being controlled. Generally speaking, non-competition provisions in terms of the employment relationship simply aren't enforceable. There are some particular exceptions. Herbert Morris's Carmen explains in her paper that deals with that. But generally speaking, all you can really protect, usually as a matter of practice, is to prevent a former employee from soliciting your customers or your clients, and from soliciting or taking away employees with whom they worked to join them in their new venture. And my own view is that I think the simpler these clauses are kept, the greater the prospect of them being enforced. It also conditions the client's expectations. If you as a solicitor have prepared a covenant which is in those incredibly broad terms, and then the time comes to enforce it, the client, not unexpectedly, is going to have certain expectations. Well, you prepared that contract, you included a clause like that. Now you've got this bozo barrister down in Old Dixon or wherever who's telling me it's not enforceable. Who am I to believe? I tend to be fairly conservative and fairly clear in my views on these things, and I think the shorter, simpler you keep it, the better the prospects of having it enforceable. I'd welcome if anyone's got any different views of that on the panel. That's certainly the view that I've got.
The only point that I make, I think someone picks this decision up in the paper, there's a decision of art, to talk about the purpose of approach the court might bring. The court will bring the underlying public policy approach that these avoid to bear on interpreting the terms of the covenant. So in arts and, remember, there was a clause that prohibited competition, which was found to be enforceable. The competition was defined in an exceptionally technical way, so that the manufacturer of chocolate biscuits was not in competition with the manufacturer of chocolates. So, to that extent, that the courts do sometimes take a purposive approach.
So they, in a way, they got to the same, or almost the same outcome. They interpreted the clause in a way that was enforceable, but so narrow that, in a way, it was the same as just rendering it unenforceable or very limited at least.
Yes, sir.
Following on from your reference to non-solicitation of employers and staff, what's the panel's view on the clauses you see which require the former employee to resist approaches by staff and customers to them? So they've agreed non-solicitation, but that's the reverse, where the customers rather than staff. The staff or customers come to the ex-employee and say, we want you to do our work, or we want to work for you. Do they ever survive?
Look, if what you're protecting is customer connection, then you can see how non-solicitation relates to that. But on the inverse, because there's a strong customer or a risk of a strong customer connection, it is foreseeable that customers are going to try to pursue an employee to their new venture because that employee has a lot of knowledge of their business or whatever it is. And so that's why, however it's expressed, whether it's expressed as you can't accept solicitation from a client or you can't provide services to a client for a period of time, it does fall within the scope of what might be a reasonable restraint on a former employee to protect that interest, which is customer connection. And that's how it seems to me to be described.
And solicitation is much wider, is it not, than just approaching somebody? It can encompass being approached by and actually then soliciting. Is that your understanding of the situation? In other words, you don't have to actively approach somebody to solicit their work contrary to a restraint clause. You can actually be approached by them initially, but then be found to be soliciting.
Depends upon what you do after that initial approach. Ultimately, it's going to depend on the facts of each particular case. I think it's fair to say that, for example, some sort of general advertisement in a trade publication that so-and-so is now operating at a particular firm or so forth would generally not be seen to be solicitation. It usually does require a somewhat more positive step. In terms of who makes the first step, yes, I agree with you that to a large extent it's neither here nor there, it's what happens after that.
And if the customer makes the first step and the customer has already set a relationship with the former employer, that would also be a fairly important factor to take into account too. As in, if the customer relationship that you're trying to protect is already severed, then the customer going and tracking down the ex-employee is going to be...
I think that's right.
Yeah.
My initial response to your question, the scenario you posed, was that it's probably not enforceable to effectively stop customers or clients going to whoever they would choose. And I can't really see, unless there was some misuse of information or something along those lines, I can't see how that would breach a fiduciary duty either, aside from any express or implied contractual duty.
Although the Court of Appeal decision that Carmen opinion does have something to say about this, because there the company actually did seek to restrain the particular employee from accepting approaches from customers or clients for whom he had worked while he was in the employ of his employer. And the court said, well, prima facie, because there is such a strong customer connection as a consultant, he's out in the workplace, he's the emanation of the employer's business, prima facie that sort of clause isn't unreasonable. However, the clause has been struck down on other aspects, principally the duration in terms of length of time. 12 months it was found was simply too long in that particular case.
So that is a situation where the customer goes to the former employee, that would very much depend on the facts of the particular case. An accountant who doesn't have any specific confidential knowledge in the former employee just has looked after their particular business. He leaves, or he or she leaves, goes off work somewhere else. The customer says, I like that person, they know my business, I don't want to work for this firm, I want you to do my, and follows them, severs the relationship, look, you're no longer doing my work, goes and finds them. There's no actual confidential information as such that's relevant to the former employer. In those circumstances, just to what you're saying is, well, yes, the court may say, well, it's unenforceable in that scenario.
No, what I'm saying is the court may find it, say the clause is enforceable.
The one where it says you can't, where the clause you talk about in the Court of Appeal matter that you're in, but if it doesn't have that specific wording that includes both customer approaching and you approaching your customer, just a more run-of-the-mill one which just says general wording, would it still be enforceable?
The scenario you described is very much like the Bourbon Code Court of Appeal decision. That's about the accountant who, interestingly, was named Mr. Money. Really. That was a customer connection case. That was the connection. He was trusted by that client. It was a 3-year restraint to prohibit him from providing services to that client for 3 years, that was held to be reasonable in that context. For those reasons you've described, the customer liked that accountant, trusted them, knew that they knew their business, would follow them anywhere. So in that context, it was held to be a reasonable restraint.
Isn't there an argument, though, on the public policy that the customer has the right to choose who they want?
Absolutely, and you can't, you've got to remember the restraint only operates on the employee. It doesn't stop the customer from going elsewhere, or you can't enforce it against the customer. You can't stop them from switching horses, if you like. The only context where you might see that arise is the one I was talking about opportunistic disintermediation, where you're a labour hire firm and you might sign your customers up on their agreement and your employees to each promise that you won't, cut the middleman out.
I think it comes back to the legitimate business interest, and that's the starting point. Customer connection in a particular circumstance is a legitimate interest that can be protected. Then in the circumstances of the case, look at the wording of the clause, and if in the particular circumstances, whether it includes accepting the customer approaching the ex-employee or vice versa, the clause goes no further than is reasonable to protect that particular legitimate interest in the circumstances, it can be enforceable. And so that's why I think in the particular case we're discussing whether the provision, the covenant included approaches by clients was appropriate because the customer connection and legitimate interest in that circumstances, the covenant went no further than was necessary to protect that legitimate interest. And I think that's the way.
What do you advise the customer in that situation? They want to go with somebody. Their former accountant or the former firm says, no, we don't want you to go there. We don't want you to go with him or her. The customer says, well, where am I? I want to choose who I want to do my business with, who I want to do my work.
If the customer is aware of the restraints, there is a prospect of the old employer pursuing them in tort for their involvement in the breach of the contract. And there is some authority where that has been successful.
Not a good look in terms of their former employer.
No, it's not. And in practice, it doesn't happen very often.
Well, this might be the final question. Yes, sir.
Can you see an instance, or can you comment whether they would apply to solicitors, that Bird & Co case? Employee solicitors?
I have no reason to see why it could not apply to employee solicitors. In many ways, I think the nature of the relationship between solicitors and their clients and between accountants and their clients is very similar. There are some differences. I think it's probably fair to say that accountants usually have a closer ongoing relationship with their clients than solicitors normally do. But certainly there are some very, very key similarities.
I mean in terms of time?
3 years.
The 3-year period.
Ladies and gentlemen, what do you think about that?
It's a long time. It's a long time. That's the gut reaction, I think. It seems
Probably too long in almost any.
It's
I think the other thing to bear in mind in the Court of Appeal decision is that there was a provision there for liquidated damages. And in those circumstances, I think the court had a degree of comfort in terms of enforcing the covenant. Had there not been such a provision and simply a question of enforcing a covenant of 3 years, I think the result would have been different.
Yeah, but with an accountant though, you're tied at the wrist, aren't you? With a solicitor, you come and go in terms of work. So that is one of the differences. So that's right. Mind you, can make a lot more money out of a client as a lawyer than you would as an accountant, because depending upon the nature of the work that comes through your door. Yes, I agree with that. So 3 years is too long? My view is yes, clearly. Cascading down? You've heard what I've had to say. All right, ladies and gentlemen, thank you for your questions. Thank you for coming along this morning. I hope you have found it valuable and has provided you some insight in this area. And on your behalf, could we please thank all of our speakers and our additional